You can spend a lifetime building your wealth, but a single unforeseen event can wipe it all away. I'm talking about two things: divorce, which ends more than half of all marriages in the US, and the reality of an unexpected death. The problem is that most people stick their head in the sand and ignore this reality until it's too late. Having the right legal structure is the solution, and in this video, I'll explain the critical steps to protect what you've built. Now, should there be asset protection language against the remarriage of the husband? Because it could be that he's going to fall in love, let's say with Jeff Bezos and Lauren Sanchez, and he suddenly forgot all his other 4 children from his wealth.
The Fiscal Fortress, where wealth meets wisdom.
Hello, Michelle. Great to see you.
Great to see you too. How have you been doing?
I've been doing really well and particularly excited about today's episode where we're going to be talking about saving money.
Yes, I would agree. In today's topic, I was thinking of covering asset protection because that's often a topic that my clients want to find out about. They want to know if they can protect themselves from losing money and hanging on to that wealth that they've worked so hard to build.
So asset protection, that's like a very legal sounding term. What for ordinary people, why should they care and how big of a problem is that really?
Well, in our country, it is so litigious. And so anytime when we go to work, anytime, whether it's in the medical field, the legal field, driving a car, all of this carries a lot of risk for a lawsuit in case something goes wrong. And so when the lawsuit happens, everything can be at risk. I recently came across a statistic that I was surprised about, saying that second marriages are actually higher. They end up with a higher rate of divorce than first marriages.
Oh, that's crazy. I think like in California, north of 50% of marriages failed. And that's really, really sad. So I imagine that what we're talking about today, could help shield some of those assets or at least create some certainty.
Yes, that's right. We'll go into details about how the trust and the LLC can keep more of that hard-earned money that has been saved to keep it in the family.
And just to be really clear, if you get divorced, the wealth that you accumulated as a married couple is known as community property. And I think under California law, community property gets split right down the middle. So you should really pay attention to this because this could be half your wealth.
That's right. In terms of how asset protection can happen in a context of a divorce, when a client comes to me, if they're a married couple, they come to me and they want to do a trust to avoid probate, to save on taxes. But I want to make sure that if they come to me together at this time, if they later get a divorce, that there is going to be some safeguards in that trust saying that in the event of a divorce, suddenly everything operates as if that either one of them has predeceased the other. That means there's no ability to do anything on another person's behalf. And so that has to kick in right away. The second thing that the trust that I create also includes is that should the money go to the children of the married couple and that money gets distributed to that child, then that money has to be put into a separate property account, that it can't be put into a joint account with that child's spouse at that time. So regardless of the marital status, the money that is given from the parents should always be put into a separate property trust.
So can we maybe just clarify or elaborate on the first point?
Sure. Very simply, when the person comes into my office and things are fine, then there's a lot of control and management over the trust because they are together making a married person trust. But in the event of a pending divorce, the rights and powers of that married couple have to be reduced, because it is not a good idea for one person to act on behalf of the other. The second scenario that also deals with asset protection is when one person has already died, but so it's no longer a divorce, but that person that is the surviving spouse remarries. If they remarry, should they suddenly have, let's say the married couple has 10 million, does that whole 10 million, is that subject to risk? Or can that part of that money be protected for the original beneficiaries? And according to the trust that I draft, it can be protected, that in the case of a remarriage, after one person has died and then the remaining spouse remarries, then a lot of powers disappear and shrink because of the remarriage.
I see. So you described 2 situations, and all things are harmonious between husband and wife, and so, of course, each party has a lot of latitude to act on behalf of the trust and control over the assets. But as soon as they're no longer aligned, they're essentially enemies. A plain Jane vanilla trust may not contemplate that situation, but a well-designed trust like the ones that you create will actually contemplate that situation and ensure that the rights of the parties are shrink so that basically one person can't do things that would be against the interest of the other party. And then in the second situation, you were saying that the maybe one of the spouses dies, and then the surviving spouse remarries, and you'd want to make sure that the trust also addresses that situation to make sure children of the first marriage are protected.
In the first scenario where there's a divorce, in that scenario, any transfers are not acceptable. That person has no authority to move any assets out of the trust without the other person's consent.
So I imagine this probably happens. The party who is thinking about initiating divorce, they start moving the assets in a way that benefits them and hurts the other party even
Right.
before they start litigating. Is that the kind of the worst case scenario here?
Sure, yeah. If we can imagine the trust being like a backpack, and if that trust says everything is 50-50 and both people signed it, suddenly, if there's nothing in the backpack, there's nothing to divide at all. And so that spouse that is the one who, say, is in a stronger financial position or not, whoever wanted to do things behind the back of the other person could move assets out of a more plain vanilla type of trust, whereas a trust that has got more protections built in would not allow that.
That sounds horrible. Really, arguably deceptive, and certainly it feels very unfair for that to happen.
Mhm. And then the second scenario would be where there's children from a first marriage, and then one spouse passes away. Let's say the wife passes away, and then the husband remarries. Now, should there be asset protection language against the remarriage of the husband? Because it could be that he's going to fall in love, let's say with Jeff Bezos and Lauren Sanchez, and he suddenly forgot all his other four children from his wealth. That would be a bad scenario. So the trust that would have asset protection language would say if a spouse remarries, then they can only deal with their half of the everything in the trust. The other half that where the wife died first, that has to go as originally agreed upon.
The worst case scenario would be that the surviving spouse basically forgets the children from the first marriage and pulls all the money out of the trust and essentially sets up something new for the second family.
It would be very disastrous. And so in the first scenario that we were talking about, suppose when Jeff Bezos and Mackenzie Scott were about to get divorced, if at that time Jeff Bezos was taking a ton of Amazon stock out of their trust. Now they live in a different state, but assuming that the laws in California applied in the state that they're in, if he started taking shares of Amazon, that would have been disastrous because that is where the wealth is for them.
That makes sense. And so the solution sounds like it's obviously planning for this in advance and having the proper legal provisions in your trust agreements. Obviously, that's very technical. You're probably not going to get that sort of protection and advice if you just like got something from off the internet or
Legal Zoom.
some software, LegalZoom, because this is really sophisticated stuff. Are there other things that you would do or a sophisticated trust and estates attorney would do in addition to improving the legal documents?
Yes, I mean, there can be a whole discussion about, and I don't want to get into too much technical talking about the irrevocable trust, but whether or not, so a lot of times clients hear and read about AB trust or ABC trust. Now, when the first person dies, then it's a choice of whether to make B and C an irrevocable trust, which would accomplish asset protection, or to keep everything in the A trust, which is a survivor's trust. If it stays in the survivor's trust, that means that that surviving husband in that prior example would have full control over the entire 10 or 20 million dollars saved. But if there was a mandatory funding of a B and a C trust after the first spouse passes, then there would be asset protection because there would be language that says that he can't take all $20 million of the couple's savings for his next marriage.
It seems really clear to me that when we talk about asset protection, I think a lot of people, and I'm guilty of this, I thought, oh, it's to protect the breadwinner, right? because it's basically being really, really clear what happens in the event of a divorce. But you've made it really clear that just as importantly, it helps the other spouse who isn't the breadwinner and his or her children because it creates a lot of certainty.
That's right, and we didn't talk about the part about the stronger position person and why they would want to do a trust. Because I have one currently where there's a party in this marriage that one is making all the money, and so the reason why he's the one who's calling me wanting the trust is because he wants to make it clear that if anything happens to him, that a part of his money goes to his siblings and to his parents. He wants to make that clear because if that's not clear in the trust that there's a certain amount of money that he owns, which he considers separate property, then if he dies without the trust, then the surviving spouse would assume that everything belonged to that person.
Yeah.
So it's very important to be clear.
I could also imagine a situation where, the stronger, financially stronger partner, maybe they divorce or they pass away, and they would want to make sure that if their surviving spouse remarries, that the children from the first marriage are cared for.
That is very true. So everything gets incredibly complex because I have another scenario where the person passes away and wants to provide for the surviving spouse's lifetime, but then the children don't want to wait 30 years before that person who was a second spouse, a remarriage spouse, doesn't want to wait 30 years until that person passes away. There's a lot that needs to be considered at the time of making the trust.
I imagine that one of the issues that people have is that this stuff is kind of depressing, right? To think
Mhm.
about death and to think about breaking up with your beloved and divorce. And I know, and I'm guilty of this. I think everybody is. Like, I tend to delay, sometimes indefinitely, things that I don't want to think about. And, one of the things that might be helpful, I mean, if people listen to this video and they realize, oh, if you just stick your head in the sand like an ostrich, this could come back to bite you.
Yeah, I mean, if you love the family, the people that you're with, you want to make sure they don't have to you want to spare them from having to go to court to fight for things. And so if in that example where the financially strong partner wanted to give something to his mom and dad and to his siblings that they all agreed to buy real estate together and didn't want it to go to his spouse if he passed away, then if you love them enough, you need to do that because otherwise it will be a battle in court. And so it really is something that, making a trust is really for your loved ones because some people say, what do I care? I'm dead already. So let them fight. And if that's the attitude, then that's just, that's the lawyer's profit because probate fees are extremely expensive and legal fees. And so the best thing to do if you want to maximize the amount of money to your family is to put all this in writing so that there's very little left for, just uncertainty.
That's really well said. I've never thought of the fact that this is an expression of love. This is a way that you can do things in your lifetime to help other people that you deeply care about when you can do something about it. I mean, obviously, when you pass away, there's nothing you can do. But until that point, you absolutely could do something about it. And it's not that big a deal. I mean, sure, there's some expense involved, but not compared to what it'll save. I mean, in the long term, it
Correct.
saves everybody money. And sure, there's a little bit of inconvenience and you're thinking about something you don't want to think about. But if you don't think about it, to your point, other people will be subject to the financial burden and cost and the hardship.
Mhm. To simply, I have a client where he's been married to this wife for years and years, but he still didn't want to put it all in writing to give things to her, and they're already, they've already spent 50 years plus together. So it is hard to understand sometimes, but if that's not done, then that spouse has to go to court to argue that the money belongs, to her.
Yeah, I don't want to provide too many details, but I know people very close to me and who their parents don't want to focus on these types of issues. They're elderly, they have wealth, but they haven't taken care of these types of issues, and it's really concerning. It's really concerning for the kids, and because they're the ones that are going to be left holding the bag, so to speak, once the parents pass away.
It's always like the whole thing where we say it's, "A stitch in time saves 9," or "Penny wise, pound foolish," because I have a heartbreaking case where it's, this married couple they've reached about 100 years old, but they don't have their estate planning done, and the family is just it's just the siblings, the children from that marriage, and it's the only marriage. There's a ton of conflict, and they did not put anything into a trust. They didn't create it. And as a result, they don't even own anything because they already gave everything they own to their children. And so it is very heartbreaking that where they tried to save some money on the legal front, where it's a couple thousand, maybe about 5,000. If you set aside 5,000, you should be able to get some good legal protections for your family in a trust. But saving that meant that now they have nothing in their name because they already gave it prematurely to their children.
I think that's a great place to park today's episode. Really, really interesting topic. I think that, the thing that we should all do is if you have significant wealth and if you haven't entered into a trust agreement, I would urge you to contact a trust and estates attorney as quickly as you can. Obviously, Michelle is available. Um, she's an amazing trust and estates lawyer who'd be happy to answer your questions. Just have a generic question and you don't want to call anybody, feel free to post a comment in the feed. If you like this content, please feel free to like and subscribe and share it with as many people as you can.
It'll
Thanks
give
for
us encouragement. Yes, it'll give us the necessary encouragement that somebody's listening to this conversation.
I think you're doing a lot of good by spreading this information, Michelle. Thank you again.
Happy to share the experience. Okay, take care.
Thank you. Take care, everybody. Bye.
Bye.
The Fiscal Fortress, where wealth meets wisdom.